welcome to another episode of Insider's Guide to the Law. I'm your host, attorney Melissa Levine-Pirro, and I'm the owner of Levine-Pirro Law, located in Maynard, Massachusetts. Each show we bring to you various legal experts from around Massachusetts to talk to you about various areas of the law. We hope that you will send your questions in at the end of the show. We provide an address, and each episode we pick those questions that are most appropriate to answer on the next show. With me today, I have attorney Carolyn Romano. She's of counsel to Levine-Pirro Law in Maynard, and her areas of focus are special needs and estate planning is what we're going to be talking about today. So welcome to the show, Carolyn.
Thank you, Melissa. Happy to be here.
So Carolyn, what areas of law do you practice in most?
Well, I practice special education law, some probate, and estate planning.
And why do you practice estate planning?
Well, it's really important to me to be able to help people figure out what kind of legacy they want to leave, what they want to do with all of the assets they've accrued over their lifetime, how they want to think about sort of their final disposition, who they want to sort of take charge of things. So really to help kind of put people at ease and provide them with the information that will do so.
That's great. So clients all the time and people at home hear the words, your estate plan. You need to do your estate plan. What is an estate plan? What makes up an estate plan?
It's a great question, and there is a lot of confusion out there. Basically, there are 5 what we call core estate planning documents that you and I put together for folks. We'll look at each one in turn. The first is a will, a last will and testament, and that's where people can state what their final wishes are as it relates to their property, all their assets, who they would want to be guardians of their dependent children, their pets if they have them, any kind of your watches, your jewelry, your china, those kinds of things that can be specified, and things of that nature.
And I think one point that you just brought up is guardianship. And that's something people don't think about, especially married couples. They assume that if one spouse passes, then, the child's automatically going to have the other spouse there to care for them. But what people don't consider is a lot of times something happens to both spouses at the same time, unfortunately, even if it's just, temporary incapacity.
Right.
And what they don't realize is that when something happens to them, if there's no guardianship provision in place, there could be a huge legal battle. Your children could be going to members of your family that you're not comfortable with.
Right, and the court is basically deciding that. So it's really important that, if you do have minor children, that you take the time to figure that out, as difficult as it may be, or, sometimes people are worried that they're going to hurt a family member's feelings if they choose one sibling over another, but it's too important not to have that figured out. With a will, you get to name your executor, which now in Massachusetts is called a personal representative. They're the person that helps settle your estate, takes care of all your affairs once you pass.
And I know with a will, just for our viewers at home, you can't handwrite a will. It has to be typed up. It has to be witnessed by 2 individuals who are of sound mind, and it has to be notarized. So the best bet for people at home is to see an experienced estate planning attorney in executing a will, correct?
Absolutely.
And not to use your self-help sites like LegalZoom and things like that, right?
Yeah, absolutely. You want to have these things done well.
And in a way so they can't be contested after these people pass.
Right, and there are lots of issues too. If depending on the size of your estate, you want to make sure you understand any kind of tax implications of the planning that you're doing. If you have a child with a disability, you want to make sure that you're allocating assets appropriately for his or her care. If you might need long-term care that is paid for by the state, you want to make sure that you're putting things in place through your entire estate plan that's going to sort of account for all of those things. So you may not even realize that you have issues that you need to discuss with someone. So it's just really important to consult with an attorney.
Because an attorney is going to be the one that asks you those pressing questions that you might not have thought about. And
Absolutely.
It's really going to personalize that last will and testament for you.
Right.
So we've got the will as the first core document in our estate plan. What's next?
Well, that would be the durable power of attorney. So now your will is in effect for, once you die, things happen. With your durable power of attorney, that is something that is in effect while you're still alive. And so that is where you would designate an agent or more than one agent to act in your behalf on your business matters. So your banking, your real estate, if you own a business, they're able to kind of step in and run your business. Pretty much anything you can think of in that regard. Even what they call digital assets. So your Facebook page, that needs to get managed, right? If you're not available. And so, it used to be that attorneys would recommend that people do sort of a springing power of attorney, where, it wasn't until you become incapacitated that it would, be in effect. But nowadays, it's, things are kind of shifting to the other way, where it's effective at the time of execution. And this is because it can be really difficult to get two doctors, for instance, to say that a person is incapacitated, especially with folks who have Alzheimer's or illnesses where, sometimes they're doing okay and other times they're not. So we now, as you know, recommend that people don't do a springing power.
And with the durable power of attorney, and they can even do mundane tasks for you, like pay your mortgage, pay your rent, right?
Yes, and if you're unavailable for any reason, if you've got one that's effective when it's executed, that person can step in for you. So if you happen to be out of the country or otherwise unavailable, you have someone who can act, in your stead.
Or if you just don't want to deal with it, make
Absolutely.
someone else deal with your financial institutions.
Absolutely.
It always works for that too. All right, so now we have a will and a durable power of attorney. What's another core document in the realm of estate planning?
Sure. The next one I think we should discuss is the healthcare proxy. So this is a similar idea to a durable power of attorney. You would appoint someone who would make decisions for you about healthcare, so your medical decisions, if you are not able to. So you want to make sure you choose someone who you trust, who sort of knows what your sort of tendencies are when it comes to, healthcare and wellness and medical procedures, and so they can talk to your doctors, they can make decisions about treatment when you're not able to, and things of that nature. Now, it's also important to know that you can override that. If you are able to communicate and you have some kind of decision in your healthcare proxy about a potential treatment that you do or don't want, and you change your mind in the moment, you're able to say, you know what, I know I said that before, but now this is what I want to see happen.
Right. And I think people have a lot more experience with healthcare proxies because every time you go to the hospital now and you're having even a minor surgery done, they encourage you to fill out a fill-in-the-blank kind of healthcare proxy on the spot. But I think anything an attorney can draft for you is a lot more detailed and a lot more personalized than any form you'd fill out at a hospital.
Right. It will absolutely be comprehensive and try to anticipate every single potentiality that could exist. Now, sort of in tandem to that, what would we also, as an estate planning document, part of the core, would be a living will. Now, these are not binding in Massachusetts, but they're generally honored by, the agents that you select.
And can you explain kind of in basic terms what a living will is for our viewers?
Yeah, a living will basically is a statement of what kind of treatments you do and don't want as it relates to your health care. So typically they, zero in a lot on sort of end of life kinds of decisions because that is a big question mark for people that are making decisions on your behalf. So to the extent that you have an idea of what you want and don't want in terms of life-sustaining treatment, DNRs, that sort of thing. Now, many people will say, don't keep me hooked up to machines. I don't want that kind of a thing. Don't do anything to unnecessarily prolong my life. I can absolutely get behind that. I know one thing, though, that we like to do at the firm is talk about hydration. That's one thing that is considered to be a life-sustaining procedure. So if you were to rule out all life-sustaining procedures without carving out that exception, that wouldn't be available to you. And while that does sort of extend life a little bit, it does make a person much more comfortable. So again, here's an example of something that a person might not really be considering or realizing as part of the discussion that we're able to raise with folks.
And I think living wills are really important too. We've all seen horror stories in the news about spouses fighting with maternal or paternal parents about whether or not to keep someone on life-sustaining treatment because they don't have a document in place. And at one point they wanted it, and one point they didn't, and no one knows what to do.
Right.
And it stays in limbo. Sometimes it's litigated in court, which is something no one wants to have happen.
All while someone is lying in a hospital bed and needs some decisions to be made pretty quickly. So one thing to think about as well is that if you decide to have more than one agent, more than one healthcare proxy, you should have an odd number. Someone who can break the tie if you're all going to be conferring together.
Right. And I think that's something we can talk about. So on healthcare proxies, you name a single person usually to make your healthcare decisions for you in the event that you're incapacitated. And I think for our viewers at home, it's really good to know that you should have backups. You should have at least 1 or 2 backups, because if there's ever an emergency where a decision has to be made instantly and your first agent is unavailable, maybe they're not answering their cell phone, it happens, you want that doctor to defer to the next person on that list, not make a decision as, the on-call doctor who doesn't know you, doesn't know your personal preferences. And to Carolyn's point, you can have co-healthcare agents. You can have multiple people serving simultaneously as your healthcare agent, but the reason to have an odd number of people is if they don't agree, you want a decision to be made. You do not want this to go to court. And you want your healthcare proxy to say, majority rules if there's 3 people.
Absolutely. And, I know this is a sticking point for some folks, especially who have, 2 kids and they, don't want to, one to feel like, they love Johnny more than Sue because Johnny's named. So, but it's too important to not really have the conversation, explain, to your children or, family members why you're making the decisions. Blame it on your attorneys that, you were really encouraged to, put your documents together in this particular way for everyone's protection.
Right. And I think it's important to know that even if you're not named on a healthcare proxy, you could still name that child on your Hipaa release, which I'll give the floor back to you to explain kind of what that is.
Yeah, so as part of the core estate planning documents are these things called Hipaa Releases. And Hipaa stands for the Health Insurance Portability and Accountability Act. And
Say
it was
that 3 times fast.
Exactly. That was passed back in 1996, a piece of federal legislation that is designed to protect people's medical records and other, personal health information. And so, really valuable thing to have in your, estate planning toolkit are these Hipaa releases that give whoever you designate the ability to see your, medical records and information. So you absolutely want to make sure that you're thinking who might need access to information about me.
Right, and we know hospitals are sticklers, so if one child is named and the other one's not, they will not have access to talk to doctors, see those medical records, things like that.
Right.
So it's very important to make sure you include everyone you want to on those Hipaa releases. And they're a very easy document to execute, and hospitals will accept copies, so it's not like you have to keep re-executing them.
Yeah, absolutely.
So lastly, in the core documents, I'll just give it away, we have final disposition instructions.
Yes, we do.
Do you want to talk about those a little bit?
Sure. So final disposition instructions are just that. They're instructions that you leave behind that sort of indicate what you want to see happen to your remains. Do you, want to be buried? Do you want to be cremated? If you're, buried where, cremated? Do you want to be interred? Do you want your ashes scattered over the Pacific Ocean? It also will sort of indicate what your preferences are for your memorial service. If it's optional, if you want to detail these things, you certainly can. Are there particular songs that you want played?
And we've had that.
We've
had people who have specified throwing parties, not funerals.
Absolutely,
and
right.
Down to the music and the food.
I mean, exactly.
If you care, you can do it.
Right, and in some regards, it does sort of give people a last sort of insight into who you were when you walked the earth. So there's really some value there. It also helps make some of the decisions a little easier for your family members who are, grieving your loss and needing to, move forward quickly with decisions related to, your final disposition.
Right. And I think it's important to know too that if you haven't made pre-death arrangements, that's something you can do and then modify in your will later. It's just something that we like to always bring up to people so they can keep it, on their mind. Understand that, a lot of times funeral expenses are extremely expensive. They're burdensome, they're distracting. So anything that you can do to make it easier for your loved ones, we usually see a lot of appreciation there.
Absolutely. And just really, to that point, having some conversations with your loved ones about all of these things. It's very difficult in our society to talk about death. There's some funny quote about, I know everybody has to die. I just always thought an exception would be made in my case. That's sort of how we approach things. So really to, realize, obviously it's, how we live is more important, but we also need to address, when we die, what do we need to do for folks who are, left to carry on.
Right. So just for our viewers at home, if someone tells you you need to have an estate plan, this is what they're talking about. They're talking about these core documents: your will, your durable power of attorney, your healthcare proxy, your living will if you want one. It's an optional document, but if you have strong feelings about being on life support, being resuscitated, having hydration, having nutrition, having painkillers, that's your opportunity to get your voice heard when you're not able to voice it for yourself. Having Hipaa releases in place, having final disposition instructions. I mean, these are all really important things that make up your estate plan.
Right.
And I think what people don't realize is that unlike other areas of law, you need a divorce, you're going to call an attorney right away. It's very easy to put off your estate plan. Very, very easy. But, maybe you could talk a little bit about why it's not a good idea to do that.
Well, sure. For instance, as we mentioned at the top of the show, if you have dependent children and you need to figure out who you would want to take care of them if something should happen to you, really important to have that, the proper documentation drawn up. If you don't want a judge deciding or the state law deciding how your assets are distributed, really important for you. I remember, in the case of one client who came into the office inspired by the fact that her family member was in an accident, was not able to communicate, had no documents, nobody could intervene, no one could support, no one could have access to his information, and it was an incredible crisis for the family. So it's really about preparing for things that we wish we didn't have to prepare for.
Right.
But once you have those things in place, you can kind of breathe a little more easily.
Yeah.
As can your family members.
So I think a common misconception is that if you don't have a will, if you do have a will, you are going to avoid the probate process. And that just isn't true.
Right, it's not true. It certainly makes things easier to have all of your documents in order, but you do still need to go to probate, file your papers, that sort of thing.
Right, and we will be doing a separate show on probate, but just so the viewers at home know, there are 3 different levels of probate now because Mass has adopted the Uniform Probate Code and amended it for Massachusetts. So you have your lowest level of voluntary administration, then you have informal probate and formal probate. And each one is a little bit more complicated than the next. But by having a will, it makes that probate process so much more streamlined and easy because somebody knows what your wishes are, and that personal representative, which used to be called an executor, can follow your wishes and carry them out in an orderly fashion. Whereas if you don't have the will, what happens is whatever the state scheme is that says how your property will be divided, that's where it goes. And if you don't have a guardian in place and you have minor children and there's no other spouse, then you have a custody battle. Or maybe you're divorced and your other spouse only has every other weekend visitation. Then perhaps you get into a big guardianship battle with the grandparents on, the mother and father side, and nobody knows what your wishes are because you didn't specify it anywhere.
Right. And a real almost minor reason why people don't go forward with getting their estate plan written is because they think, what am I going to do with all my stuff? How am I going to sit down and figure out what I have and who should get, my jewelry and who should get my, stamp collection and that sort of thing. So, 2 things that I want to point out, first of all, is that typically nowadays people leave things in percentages. They may not know in 20, 30 years how much of, an estate they'll amass. So they say, okay, I want to leave my estate equally to my 3 children, that sort of thing. So that kind of helps with that issue. The other thing about, who gets grandma's wedding ring can be handled with a memo that now is available for folks, where it's just, a one-page document where you can list out who gets what, out of your personal possessions. It's something that is binding, it's part of your will, and you can change it at any point. So if every year you want to take a look at, any new things that you've, acquired, or, you
Someone
decide.
pisses you off.
That's right. Someone, is no longer in your good graces, you want to shift things around, you
Right.
have a new grandchild to consider, that kind of thing. You can very easily, and even later on, you can have all your documents executed, and then, over, with a cup of tea in one hand and your pen in the other, you can start thinking about all of these possessions and who should get what.
Exactly. So in addition to core estate planning documents, there's always add-on documents you can do, depending on your personal situation. So there's one I want to touch just briefly because we always get a lot of questions, and because you and I are both dog people. So that's pet trusts. That's gotten a lot of media attention over the last couple of years, and people always come into the office and ask us, what's the deal with pet trusts? So Carolyn, what's the deal with pet trusts?
Well, with a pet trust, you get to say who you want to take care of your dog, what assets you want to have available to take care of your dog, what's, special ways your dog needs to be cared for. You really get to delineate all of those things.
And it's really not as silly as the media makes it out to be, because I know that we've had plenty of clients that are nearing the end of their lives, but they have very young pets. They might have a dog or a cat that's only 2 or 3 years old, and it's very likely that the pet's going to outlive them.
Right, and often, unfortunately, end up in a shelter.
Right, and that's what people don't want to see happen, and have their pet end up in a shelter.
Right, I've seen many listings since I'm involved in rescue of, elderly dogs, senior dogs, beautiful dogs that for no other reason than that their owner died, that they're there, and may end up being euthanized. So it's really, as you're saying, it may sound like a funny thing, oh, I have a pet trust, but really thinking about, that member of your family too, and what will happen when you're gone.
And I think what people don't really understand is when you give your pet to someone, even if they want to take your pet and take care of it, there's a financial burden tied to that. So if you can set aside in your pet trust, in your will, X amount of money that's going to go into the trust for the care of your pet that this person can use, to cover vet bills, to cover food, things like that, emergencies, they add up. It can be hundreds to thousands of dollars, especially if it's a young pet. So you don't want to be a burden on the person that's willing to take care of your pet when you're gone.
Right, and it actually might make them more willing to take care of your pet as well, because they're, it can be burdensome financially. You're absolutely right.
It can. And then if there's money left over, I assume those people can have it fall to the residual in their will, or go to a charity, give it away, something like that. And that works really well.
Yeah.
So just briefly, I know that we'll have a whole other episode on this. Because of your expertise in special education, special needs trusts are a big component that people can add on. And in this day and age, there are a lot of children with special needs, or family members that have special needs. So how are special needs trusts utilized in the estate planning process?
Great question. If you're a parent of a child with a disability, sometimes you think you could never die, because you just don't know who, especially if your child has complex needs, you don't know who would take care of your child, how, all of those things. So that actually something so important, and the families know is so important, there's delay involved. They know they need a trust, or they've heard of a trust, but they don't know exactly what that entails and that sort of thing. But what a special needs trust does is that it allows your child with a disability to be taken care of with extra resources that you provide in trust for them, so that they don't become ineligible for government benefits that they may be currently receiving, or that they may receive in the future. So it's really a way to improve quality of life many times, to provide for things that government benefits don't provide for.
And I assume peace of mind for parents, too, who are worried about these special needs children after they go.
Absolutely.
I mean, that's huge.
And it's just a vital part of an estate plan if you have a child with a disability.
Right. And I mean, very briefly, just as we're wrapping up, trusts in general. I mean, we've talked about pet trust, we've talked about special needs trust, but there's a lot of things you can do with trusts to personalize your estate plan more, to help with taxes, things like that, correct?
Absolutely. And it's also a private process. So some people really gravitate towards trust because they want, their business to remain private. There's also the issue of Medicaid planning for folks who, don't necessarily know for sure whether they'll need nursing home care that's paid for by the state, but they might. So is there a way that assets can be protected? And all of that is fodder for discussion in a consult or, about an estate plan.
Right, because Medicaid planning is very tricky. I mean, Medicaid has that 5-year look back to see if you've moved, changed around assets, what's in your estate, how much is in your estate, what the health and situation is of your family members. I mean, it's complicated, and everyone's situation is a little different and requires, personal attention and planning, I think.
Absolutely.
But trust can be used for a variety of things too. I mean, you can skip generations with who you give gifts to, give it all to your grandchildren, save on death taxes if you're creative enough. So trust can be utilized in a variety of different ways. And, not just for your pets, not just for special needs children, just in your general estate. But I think it really depends on a lot of different factors if you need trusts, and a lot of times they're overused by attorneys.
Yes, that's true. We've dissolved a number of trusts so that we could do things that made more sense.
Right, and a lot of people can survive with just a basic estate plan, those core documents we recommended. That's the minimum of what you need. That's what will protect you. And then you can consult with an attorney about if there's additional documents that you and your personal situation might benefit from. So Carolyn, it's been wonderful having you on the show today.
Thank you, Melissa.
I think our viewers at home really got a lot of information, great information about estate planning and how they can plan for the future. So for everyone at home, we will see you again next month on Insider's Guide to the Law. Thanks for staying tuned.